J'ouvre maintenant la séance.
I call this meeting to order. Welcome to meeting number 42 of the House of Commons Standing Transport.
Do we have translation? Sorry, everyone. We're just going to suspend for a minute or so. Maintenant la séance.
I call this meeting to order. Welcome to meeting number 42 of the House of Commons Standing Committee on Transport, Infrastructure and Communities pursuant to Standing Order 1082 and the motion adopted by the committee on Thursday, February 3rd, 2022. The committee is meeting to study air passenger protection regulations. Today's meeting is taking place in a hybrid format pursuant to the House Order of November 25th, 2021. Members are attending in person in the room and remotely using the Zoom application.
Appearing before us today, we have from the Canadian Transportation Agency, Michelle Greenshields, Director General, Dispute Resolution Branch, Tom Uman, Director General and Analysis and Outreach Branch. And from the Department of Transport, joining us virtually, we have Craig Hutton, Associate Assistant Deputy Minister, Policy, and Colin Stacey, Director General, Air Policy. In the second half of our meeting, we have from the National Airline Council of Canada, Jeff Morrison, President and Chief Executive Officer, as well as from WestJet Airlines, Andrew Gibbons, Vice President, External Affairs. I'd like to take this opportunity to inform members that all of today's video conference witness participants have completed the necessary audio-visual checks. And once again, I'll look over to my esteemed translators to get the thumbs up to make sure that everything's okay. Fantastic. We will begin with the opening remarks of Department of Transport for 5 minutes. I turn the floor over to you.
Good afternoon, bonjour. Thank you, Mr. Chair, for inviting me to speak with you today. C'est un plaisir pour moi de me joindre à vous.
It is my pleasure to join you and the honourable members of this committee. I welcome this opportunity to share how the Government of Canada has been working to strengthen Canada's air passenger rights regime. I am pleased to be joined today by Colin Stacey, Director General of Air Policy at Transport Canada.
Transportation Modernization Act and subsequently the Air Passenger Protection Regulations, or APPR as they're known, passenger rights were not widely understood nor consistently applied across air carriers in Canada, including the fact that rights were different for international and domestic flights. The APPR fully came into force in December 2019 with the objective of creating a more predictable and balanced approach to ensure that passengers know their rights, air carriers understood their obligations, proper complaint resolution and enforcement mechanisms were provided, and that operators don't face an undue burden or lose competitiveness in adhering to these rights, including in a way that could negatively affect ticket prices for consumers. These regulations were developed based on best practices from the United States and the European Union. The regulations govern the treatment of passengers by air carriers, as well as clarifying minimum standards of treatment and compensation that must be provided to passengers based on the level of control an air carrier has over a flight disruption. Separately, the mobility rights of persons with disabilities are protected under the Accessible Transportation for Persons with Disabilities regulations. These regulations came into force in June 2022. With the APPR, Canada has a robust set of regulations to protect Canadians when they travel by air. In many instances, passengers are eligible for compensation. The Canadian approach goes above and beyond other jurisdictions in some areas. For example, the APPR provide for compensation for delays and cancellations within a carrier's control, which does not exist in the United States. Also, carriers are required to rebook passengers on a competitor carrier in certain situations, which is not the case in either Europe or the US. As with any new regulatory regime, we would expect it to be tested by practical experience. In the case of the APPR, this has happened in a way that's beyond what could have been imagined. Indeed, the regime has been tested by the worst crisis in the history of commercial aviation and the difficult pathway to recovery that's followed. The result, as you well know, is a significant number of passenger complaints. It's important to recall that these complaints are occurring because the passenger rights regime provides Canadians and air carriers with a framework that outlines obligations to passengers. Complaints that go to the agency are the ones where there is doubt about the application of the regulations. The typical first step is an attempt at resolution directly with the carrier, where a complaint can be resolved without any agency involvement. Where complaints are advanced to the agency, we understand that a large number of these are resolved by facilitation, which means that the agency is often able to provide a resolution for travelers. In other instances, decisions are adjudicated, which can also provide relief to passengers, as well as clarity around how similar situations will be treated in the future. Such possibilities for satisfying passenger complaints would have been much more limited with the system that existed prior to Canada's air passenger rights regime. The agency has processed over 25,000 passenger complaints by different dispute resolution methods since the APPR came into full effect in 2019, and additional temporary funds for 1 year were announced in Budget 2022 to increase the agency's complaint processing capacity. Recognizing that the agency plays an important role in supporting the efficient functioning of the national transportation system, the Government of Canada continues to work with the organization to address its financial requirements to ensure it's resourced appropriately to carry out all of its mandated functions, including consumer protection for air travelers. We are improving the APPRs based on experience. When a gap in the APPR was revealed at the onset of the pandemic, namely that carriers were not required to provide refunds for cancellations that were not within their control, and where no alternative travel was possible due to the pandemic, the Government of Canada quickly acted to close this particular gap. Based on direction from the Minister of Transport, the agency's new regulations ensure that even when cancellations and lengthy delays occur that are outside the airline's control, passengers can receive a refund if the airline cannot complete a passenger's itinerary within 48 hours, regardless of the type of ticket that was purchased. These new regulations came into force in September and provide greater clarity around timing, cost coverage, method of payment, and deadlines to refund travelers. Furthermore, Transport Canada continues to work in close collaboration with the agency to examine further opportunities to improve the functioning of our air passenger rights regime to ensure that it continues to be world leading, meeting passenger needs, including passengers with disabilities, and that air carriers abide by the spirit of the regulations. This includes examining recent experience in the face of challenges presented by the pandemic to consider whether additional changes to the regime are required. En outre, Transport Canada continue de travailler en étroite collaboration.
Transport Canada continues to work closely with other partners and exploring other options for the Canadian air passenger rights regime in order to make sure that it becomes a world leader in this area, meeting passengers' needs, including
Have to, unfortunately, sorry, Mr. Hutton, I'm going to have to cut you off there. I gave you an extra 30 seconds, but we will be able to get that from you perhaps in writing to add into your contribution today. Thank you very much. Next, we have the Canadian Transportation Agency. The floor is yours. You have 5 minutes for your opening remarks.
Monsieur le Président, j'aimerais...
Mr. Chair, I'd like to thank the committee for the invitation to appear today. As you noted, I am accompanied by my colleague.
Share our 5 minutes of opening remarks. Alors, premièrement, en tant qu'organisme...
First of all, as a regulator, the Canadian Transportation Agency develops regulations in accordance with legislation, implements regulations, and enforces them, and it also issues licenses and determinations. Second of all, as an administrative tribunal, the agency resolves complaints using informal dispute resolution, such as facilitation and mediation, as well as through a formal adjudication process in which it has all the powers of a superior court. The agency has a mandate for the federally regulated transportation system, air, rail, marine, and this includes the protection of the human rights of persons with disabilities to an accessible transportation network. A core component of our mandate is providing consumer protection for air passengers, most significantly through the Air Passenger Protection Regulations, or APPR. In 2018, the Transportation Modernization Act amended the Canada Transportation Act and gave the agency the authority to make regulations defining airlines' minimum obligations towards passengers. Before the development of the APPR, each airline set out its own terms and conditions of carriage in a legal document. In a legal document known as a tariff, which is in effect the contract between the passenger and the airlines. After the coming into force of the APPR, in addition to the terms and conditions set out in the tariff, each airline is required to follow the obligations as set out in the APPR. And thanks to these regulations, the rules are more consistent from one company to the next. The APPR was addressed after comprehensive public consultations, and it addresses fundamental entitlements of passengers, including receiving clear communications and being treated fairly in the case of delays, cancellations, and denied boarding. These minimum obligations differ based on the extent to which the causes of a flight disruption are within an airline's control or not. Obviously, for situations that an airline can control, airlines are held to a higher standard of treatment toward the passengers. For example, for flight disruptions that are wholly within airline control, airlines are required to provide compensation for inconveniences. Even when the events occur that are outside of their control, airlines must still ensure that their passengers get to their destination as quickly as possible. Sometimes it's difficult to determine if an event is outside of the airline's control, if it's within their control or within the airline's control but required for safety. It can be even more difficult for a passenger to determine this, as the information that would enable the passenger to determine how the flight disruption is categorized and what their entitlements are is within the hands of the airlines.
Three months after the APPR came into force, the COVID-19 pandemic caused a collapse in global air travel. As the events of the pandemic unfolded, it became clear that there was a gap in Canada's air passenger protection framework relating to the situation where flights were cancelled or delayed for reasons outside of the airline's control, and there was no possibility of a passenger completing their itinerary within a reasonable time. Because the law did not require airlines to include refund provisions in their tariffs for such situations, what a passenger was entitled to depended on the particular tariff of the airline. Given the implications of this gap in the framework, on December 18, 2020, the Minister of Transport issued a direction to the agency providing the authority to develop a regulation respecting the airline's obligations to a passenger in case of flight cancellation or lengthy delays due to situations outside the control that prevent them from ensuring that the passengers complete their itinerary within a reasonable time frame. The final regulations amending the APPR were published in Part 2 of Canada Gazette in June 22, 2022, and came into force on September 8, 2022. The new regulations require airlines to provide a passenger affected by a cancellation or a lengthy delay due to a situation outside the airline's control with a confirmed reservation on the next available flight that's operated by them or a partner airline, leaving within 48 hours of the departure time indicated on the passenger's original ticket. If the airline cannot provide the confirmed reservation within a 48-hour period, it must provide the passenger with a choice, a refund or a rebooking, and a refund must be provided within 30 days. Following the coming into force of APPR, we saw a significant influx of complaints with an incoming monthly complaint volume that was quadrupled. To put this in perspective, in 2018-2019, we received about 7,600 complaints. And while the year that APPR came into force, in 2019-2020, we received 19,000 complaints, even though the APPR were only fully enforced for 3 months prior to the onset of the pandemic. More recently, as air travel volumes have rebounded and the air industry has grappled with the speed of recovery, we've witnessed a big jump in complaints, which has only recently started to slow down. While we had been receiving an average of 1,500 complaints per month in April, May, and June of this year, complaint volumes jumped to more than 3,000 in July and 5,700 in August. Despite processing more complaints than before, in 2021-22, we processed over 15,000 complaints, which is more than 3 times the number of complaints that we were processing annually before the APPR and the pandemic. We still had a significant number of complaints, and that has led to a backlog. We're working on addressing the backlog by further increasing our complaint processing capacity through identifying and implementing procedural improvements, modernizing our processes, and adding capacity where possible. Finally, although today's study is focused on APPR, I should mention that the agency has a key human rights mandate for accessibility of the federally regulated transportation system. And I would note that when we receive cases regarding accessibility, they are prioritized, and as a result, we have no backlog in this area. Thank you, Mr. Chair. We'd be happy to respond to any questions.
Thank you very much for your opening remarks. We will begin our round of questioning today with Dr. Lewis. Dr. Lewis, the floor is yours. You have 6 minutes.
Thank you so much, Chair. And my first question, actually, I want to thank the witnesses for their testimony today. It's very, very essential that we resolve some of the angst that travelers are experiencing, especially because we've had unprecedented disruptions in flights, delays, and cancellations over the last few years. And with things such as the mandatory ArriveCAN app, I'm sure that there were a lot of complaints about that too, and the COVID protocols. But that's not the area of concentration that I'll be focused on today. Today, I will be dealing specifically with the area of compensation, and my first question goes to Mr. Craig Hutton. You had stated that compensation is provided for delays that are within the carrier's control. How is it determined whether or not it is within the carrier's control?
Thank you, Mr. Chair, for the question. So in terms of determinations, there is a process by which, as you know, the agency undertakes to determine the degree of control that is applied in any specific complaint that has been filed with the agency. But typically, situations of control can pertain to operational issues that the airline may face with respect to their network. And where it's determined that they did have a degree of control over that, that is determined to be within their control. So I can turn to my colleague, Mr. Stacey, just for some more specifics in terms of that control issue, which also was addressed in the most recent regulations that came into force on September 8th.
So operational issues, would that mean things such as labor shortage? Would that be an operational issue? Or are you speaking of safety issues?
So in terms of labor, as you're aware and other committee members would be aware, there is currently an issue that is before the court with respect to staffing and the degree to which the claims of staff shortages could be considered a safety issue. And so it'd be inappropriate to sort of comment on that specific case. But that is why, as well, that the agency is there to adjudicate to make sure the rights are respected, the passengers are encouraged to seek recourse, and that the agency can provide the clarity where there's doubt about the application
Mr. Hutton,
of the regulations,
wouldn't you know what
of the regulations.
Wouldn't you know what the labor shortages would be up front? So wouldn't the airlines be able to plan for that? Wouldn't they know that up front?
The degree to which that is interpreted as a safety issue is something that currently is the subject of court proceedings. So it'd be inappropriate for me to comment on the specifics of those proceedings until that's resolved.
Are there any lists that enumerate what is a safety issue and what is in the carrier's control? Because I would think that the passenger would see somewhat of a power imbalance because the carrier determines what information to give the passenger, and that is what the passenger will seek the remedy from. So what incentive would there be for a carrier to provide information that would incriminate them and compel them to pay damages?
Well, there are, of course, a number of cases where clearly there isn't a dispute, the passengers encouraged to work with the airline first to ensure that their complaint can be addressed by the carrier. And where there isn't a resolution with the carrier directly, then it goes to the agency for that interpretation around what the facts are in that specific situation. So there can be facilitation to arrive at that conclusion, or there can be adjudication. But it will depend upon the specific set of facts that a carrier, traveler may find themselves in to make a determination as to what the specific cause was in control or not within control, and that linkage to safety or not.
Well, perhaps I'll ask Mr. Oomen through the chair about this imbalance. And in such cases, does the agency get a list of things that potentially the airline would have done wrong? How does the passenger correct for this imbalance, and how can we expect for the public to be protected when the airline has all of the information that the passenger needs to defend themselves or to bring forth their case?
Chair, there's a question about a power imbalance, but in fact, the agency plays an important role in facilitating the interaction between the passenger and an airline. So first of all, through our informal facilitation process, an agency facilitator sits down with the passenger and a representative of the airline to air out the issues in dispute and to try to come to a resolution. That includes the details of the events surrounding a flight disruption. In facilitation, it's actually the agency facilitator who asks for information from the airline, not the passenger, right? And the vast majority of complaints are, in fact, dealt with, Chair, through facilitation. For those cases that do proceed to adjudication, the agency provides its services free of charge, no lawyers required. The agency provides extensive guidance material to assist passengers in understanding the regulatory framework and clearly explains to passengers what is required for each step in the adjudication process.
Thank you very much, Mr. Oomen, and thank you, Dr. Lewis. Next, we have Mr. Iacono. Mr. Iacono, vous avez 6 minutes. La parole est à vous.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Mr. Iacono, thank you, and I thank the witnesses for being here today. First of all, when airlines confirm that flights have been delayed or canceled because of circumstances outside of their control, how is the veracity of this proved? Mr. Hutton.
So the agency, and I'll defer on the details of this to my colleague from the agency. The specific details around a given situation, it is up to the agency to ask carriers for information pertaining to the incident. So they are able to work with the airline to determine what the specific circumstances were around any specific incident.
Merci. La prochaine question.
Thank you. My next question is for Mr. Stacey or Mr. Oomen. Why were you apparently reticent to impose fines to airlines for systematically failing to implement APPRs?
Si je pourrais, Monsieur le Président, je pense que la question.
If I may, Mr. Chair, I think that those types of questions on fines should be addressed to the agency.
So, Chair, the main way by which the agency oversees compliance with the APPR is through the resolution of complaints made by passengers against airlines. And this is because complaint resolution is helpful individually to the complaining passenger, since it can result in the passenger obtaining a remedy from the airline. Also, the complaint process allows a panel of members to interpret the regulations. The other way in which the agency oversees compliance with the APPR is through compliance monitoring and enforcement activities. And to that end, the agency does have a small number of designated enforcement officers, and our team of enforcement officers have several roles. So first, they support complaint resolution by following up on agency decisions and orders pursuant to the resolution of complaints. So they make sure that the airlines comply with the orders following a complaint decision. Also, though, they conduct targeted enforcement blitzes, they issue notices of violation and administrative monetary penalties. A concrete example really quickly of how this works together is a relatively small number of AMPs were issued for airlines not responding to passengers within 30 days of a request for compensation. So you will see on our website, we have posted those notices of violations and the amounts of the administrative monetary penalties. But while the enforcement officers were having those conversations with the airlines, that also resulted in the airlines, in many cases, changing their categorization of the flight disruption to within control and paying the passengers the compensation. So that dual role of, yes, investigating and issuing administrative monetary penalties, but also having those discussions with the airlines to ensure ultimately the goals of compliance and changing behavior.
Merci, Monsieur le Président. Il me reste combien de temps?
Thank you, Mr. Chair. How much time do I have left? 1 minute, Mr. Iacono. Rather, 2 minutes. Thank you. I'll continue. If we want to change the CTA's model, could it do this on its own? Or could the government do it on its own, or would it require legislative measures?
So what I'll say is that the agency makes regulation based on the legislative framework that the agency is presented with. So we would need either a change to the legislative framework or direction from the minister to change the regulatory framework.
Et est-ce qu'on a envisagé d'actualiser?
And has it been considered to modernize the CTA's model that would go from a quasi-judiciary organization to an administrative organization?
So the agency has these two roles. These roles are set in the law, so both as an administrative tribunal and as a regulator. So that is based on the current legislative framework.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you, Mr. Iacono. Next up, Mr. Barcelo Duval, over to you. You have 6 minutes. Thank you, Mr. Chair. I think the last time the members of the agency came to testify, there was a report on the number of complaints based on the backlog, complaints that were awaiting an answer. I think, if I'm not mistaken, it was around 18 or 20,000 complaints that hadn't been dealt yet with at that time. Could you please give us an update as to the number of complaints that have not been processed yet?
Thank you. We continue to receive a high volume of complaints, although the pace has reduced since the summer. For example, we received 5,800 complaints in the month of August, and compare this in the period before the APPR came into force, where we received 7,600 complaints for the entirety of the fiscal year, 2018-2019. Our current backlog is 30,000 complaints. To provide, there's currently 80% of those cases have been received since April 1st, 2022. We continue to work to address these cases with the resources that we have. and review our processes to optimize our processing capacity as we go forward. We've already found ways to more quickly review cases informally and formally through batching of cases, so finding cases that have a common flight and being able to handle them with a larger volume, streamlining our manual processes.
J'ai eu la réponse en fait qu'en ce moment.
Thank you. I got your the response. You're at 30,000. You also mentioned that you had increased your capacity to process complaints. You said that before it was about 5,000 or 6,000 complaints per year, and now it's around 15,000. So if there's 30,000 that haven't been dealt with, that means that there's about a 2-year wait time to deal with all of those complaints. I imagine you already have plans in place to continue improving the speed with which you deal with these. You can deal with more of them. But earlier you also mentioned that there are a lot of complaints that are dealt with through facilitation or mediation. That's the main method used. I'd like to know, do you conduct tests with people once the complaint is considered having been dealt with? Because I think there are a lot of groups. Sometimes you even batch them together and you close them up. For example, do you call on people afterwards to find out if they're satisfied with the final result? Do you have any statistics on user satisfaction?
Chair, we do in fact do a survey of the passengers who bring complaints to us afterwards, and we do measure the level of satisfaction of clients with our of complainants with our service.
Possible de transmettre en fait ce que
Would it be possible to forward to this committee information on the satisfaction surveys that were conducted? I think it would enlighten the committee as to the current situation and how satisfied people are. Because we heard from the Consumer Association that people were disheartened by the wait periods and that some of them decided that given the huge administrative hurdle, that they should just drop their complaint. So if you could let us know what the current situation is, that would be great. And it was also said that there are a lot of airlines that could say that a lot of people, not that many people file a complaint. For example, if there are 200 people who file a complaint, but everybody on the flight, for example, got false information, well, if only X number of people filed a complaint, well, and then it's in favor of the consumer. Well, my question is, do you have a way of informing all the people on that flight in question, informing them of what happened after a complaint was dealt with?
Chair, first of all, we would be happy to provide those statistics that were mentioned after this meeting. I will also say that all of our adjudicated complaints are on our website. For those that are actually adjudicated, the decisions are published on our website. That information about adjudicated cases is also provided to our facilitators, who deal with the vast majority of cases in discussions with the airline and the passenger. And so that information about the results of adjudications is also fed into that process of dialogue, that facilitation process at the beginning of the complaint resolution process.
Donc, si je comprends bien, l'agence.
So if I understand, the agency deals with the complaint either through the tribunal or facilitation, but there's not a proactive process to inform the other consumers who might have been hurt by the same situation on the same fault. So there's no incentive for an airline to say, well, I've got 1 out of 300 who complains. Well, there might be 1 out of 300 that will get, compensated, but the other ones won't get anything, right? So that's kind of my question.
So, Chair, I can't speak for the members of the agency who would adjudicate and issue decisions on each case based on the evidence before them. I will say, however, that there are means to extend parts of a decision that apply to one complainant to the other passengers on a flight. We have already informed in a number of cases, the parties to those disputes, that we will be considering extending a decision made for an individual complaint to the other passengers on the same flight. We have also more generally informed the air carriers that it is our intention to actively use these provisions. They were mentioned at an earlier hearing in this study, 67.4.
Thank you very much, Mr. Uman. Merci beaucoup, Mr. Barcel-Duval. Next, we
Thank you, Mr. Barcelo-Duval.
have 6 minutes.
And thank you to our witnesses. Does the CTA have an estimate of the percentage of passengers affected by delays and cancellations who pursue complaints through the CTA?
We can speak to the portion of complaints that we have that are related to flight disruption. So currently, of the cases that we received in 21-22, 43% of those were related to flight disruptions.
43% of the incoming
total
complaints were related to flight disruptions. But do you have a sense of, like, obviously there are thousands and thousands of people who are affected by delays and cancellations. The CTA has an estimate of how many flights over the past couple of years have been delayed or canceled. Do we have a ballpark estimate? The number that was given to us by a previous witness was 2%, that 2% of passengers are actually pursuing complaints through the process. Does that seem like a reasonable percentage?
So, Chair, the number that we found to be a reasonable approximation that we use for forecasting complaints into the future is roughly 1 in 5,000 passengers will issue a complaint.
1 in 5,000 passengers will issue a complaint. Now, as you just mentioned, the CTA has the ability to enforce these rules on a per-flight basis as opposed to a per-passenger basis. You indicated that the agency has informed carriers that it intends to use this in the future. Why hasn't the agency used this power to date?
Chair, again, I'll preface this by saying the thing I always have to say. I can't speak for members of the agency who adjudicate and issue decisions on each case based on the evidence before them. However, I will say that there are at least 2 ways in which agency decisions made with respect to a single complaint can have an impact that goes beyond that single complaint. First, and particularly important for new regulations, is through the interpretation of regulations such as the APPR. So when members of the agency interpret the facts of a case, and then that serves as a model for the cases that will follow. Given the newness of the regulation, our emphasis has been on interpretation. It is true that 67.4 or 113.1 can be used to extend elements of a decision to other passengers on the same flight. However, a couple of points to note, Chair. First, 97% of complaints that come to the agency are resolved through informal means, so most complaints don't actually make it to members to adjudicate and issue decisions. For those complaints that do get to adjudication, as I said, we have already started notifying in a number of cases the parties to those cases that it is our intention to consider using 67.4.
Okay, just to be clear here. So if someone goes through the process and it's resolved in facilitation and they get some sort of compensation under the APPR, there's no way to extend that facilitated outcome to the other passengers on the same airplane, on the same flight that were affected in exactly the same way, unless it goes all the way to adjudication?
Chair, so the way that works is the facilitators who handle a particular case, we spoke earlier about batching complaints by flight so that there's some way of knowing what complaints were from a flight. So the facilitators who follow a particular flight disruption, are made aware of what the facilitated solution was in that particular case. That information is shared with the other facilitators who may have to deal with other complaints from the same flight. So there is a common understanding among facilitators as to what happened in that case.
But I think you understand what I'm getting at, which is that if the CTA awards compensation through facilitation to 2 passengers on a flight that was canceled, all the other passengers that were affected should also reasonably be entitled to that compensation. But a lot of passengers we know don't go through the process because, frankly, it's pretty onerous. I've been through it, and it's a really frustrating process to go through. You have to wait 30 days for the airline to get back to you, and then you have to fill out all sorts of online forms. Isn't it reasonable to extend compensation, reach through facilitation to all of the passengers affected on the flight, regardless of whether they went through the process?
Chair, I mentioned earlier that through the other half of the agency, through the regulatory and enforcement half, we have been successful in having discussions with the airlines that have resulted in them recategorizing flights to be within control and therefore offering compensation to passengers. We have been successful in that. I would emphasize, Chair, that facilitation is, as the name suggests, a facilitated informal process in which there are discussions and agreement on a way forward. There is no weight of law behind a facilitated solution.
Process is the passenger provided with the information the airline provides to the facilitator?
Chair, yes, that is absolutely the case.
When a passenger gives up or takes their case to small claims, so takes their case out of the process, how does the CTA list that on its website? How do those, there aren't, I looked at the list and there's no category for people who gave up. Where do you put those people? If they withdraw or if they don't pursue their case, or if they take their case to small claims court because they're frustrated by the lack of resolution?
Chair, so complainants are free to pursue different means for resolution of their case. If they don't close it with us, then we continue to pursue the case.
Thank you very much, Mr. Bachrach, and thank you, Mr. Uman. Next, we have Mr. Strahl. Mr. Strahl, the floor is yours. You have 5 minutes.
Thank you very much, Mr. Chair, and to everyone participating there today. My questions, first couple of questions, come out of a CTV News report from today. The Minister of Transport, Mr. Al Gabra, had a presser at Ottawa Airport, and he said that he was referencing a bit of a summit that they held last week. Said that topics discussed included essentially including standards for the Canadian Air Transport Security Authority and other government agencies were things that he referenced. So the article further on says the wait time as of Monday to review air travel complaints made to the CTA can be more than 18 months. So I guess my question is, does the CTA have a service standard for responding? We heard that the airlines have 30 days to provide information, and that's taking 18 months for the CTA to review complaints. So what is the service standard, and when can we expect it to be met?
So as mentioned, we currently have communicated that it can take up to 18 months to have a case processed at the CTA. This is based on general average service times for different cases. There's a variety of factors that contribute towards how long a case takes to process. Some cases can be processed quite quickly in the early phases of facilitation, where it's quite clear that there is there's whether the airline has met its tariff or complied with the APPR, or if they have not. Other cases require a little bit further information to dig in further.
And I'm sorry, I don't have a whole lot of time, so I understand there are different reasons for different lengths, but obviously prior to having 30,000 backlogged complaints, there would have been, we have these all throughout. Members of Parliament have these service standards that our constituents, we relay to our constituents, whether it's in immigration, whether it's in currently a passport, how long that takes, et cetera. There is an ideal service standard. So without getting into why some might take longer, what is that service standard when you don't have 30,000 backlog complaints, or when these APPR was first introduced, what was the service standard? Has it ever been met? And how do you plan to get back to it?
Our plans to get back to the service standard, or service standards, are really based on trying to go through a comprehensive review process of our complaint processes. So we're examining elements such as looking at our service processes, trying to find ways to streamline decisions. So streamlining decisions, streamlining our processes, finding ways to reduce administrative burden and find those efficiencies. So for example, we were able to streamline the intake of complaints and reduce processing times or reduce failures at the application from 50% of applications to 10% of applications.
Okay, so you do have a plan to get back to the service standard, but I guess I'm still looking for what that service, what is that number? Is it 60, 90 days, a year? What is the service standard that you're trying to get back to?
Chair, I would just mention that our service standards are actually in our annual report. We don't have that off the tops of our head, but they are in our annual report and can be looked up.
Okay, I'll look for that there. Some of the witnesses that we heard from in the first panel on this mentioned because there are CBSA, CATSA, NAVCAN issues that can come up in the air passenger experience. It was suggested that if the airlines had an issue with those, or if those government agencies or affiliated agencies had been the cause of the delay that forced the airline to pay out to the passengers, that the airline could simply go back to those other parties and try to collect I guess payment, or they could go back and get a remedy from them. Does the APPR allow for airlines to recover costs from government agencies that may have resulted in delays that have caused them to have to pay out to passengers? Maybe Mr. Hutton, that might go to you.
Thank you for the question, Mr. Chair. No, in terms of the operational issues that may occur as a result of airport operations or instructions from traffic control, these kinds of issues are deemed to be outside a carrier's control, generally speaking. There isn't any provision to be able to recoup anything from those service providers who may have instigated a particular delay or instance of a problem where it resulted in a complaint from a passenger.
Okay, and as I said in that article, it mentioned other government agencies other than the CTA that the minister was looking to have standards for. Can you tell this committee who the minister's referring to, which agencies the minister's referring to, where he would like to increase the service standard or the transparency around their operations?
Unfortunately,
Yes,
Mr. Strahl, I'm going to have to ask the witness to provide that in a written form submission, as you are out of time for your line of questioning. Thank you very much for that. Next, we have Mr. Badaway. Mr. Badaway, the floor is yours. You have 5 minutes.
Thank you, Mr. Chairman, and I want to thank Mr. Strahl for his line of questioning, because that was somewhat the line of questioning I was going to go down. But I'm going to allow, with that said, Ms. Greenshields, to elaborate a bit more. I heard from Mr. Oomen that the CTA, according to legislation, I heard an administrative tribunal, I heard to adjudicate. And with that said, does the agency annually, and Mr. Strahl did ask the question, but I want you to get a bit more, I guess, deeper into the weeds in this, does the agency annually review or measure your performance?
Yeah, I'll speak to you generally. The agency does review our performance through the annual report. We have a number of factors that we publish, a core set of data that is shared and posted on our website. We also continue to monitor operational data on a regular basis to ensure that we have an understanding of our workloads coming in and our processing.
So with that, and I'm asking these questions deliberately because we really want to ensure that you guys have the mechanism and the tools to do what people expect you to do. I know whether it's rail, whether it's marine, whether it's air, whether it's road, we do receive as MPs a lot of complaints about the CTA, period. Bottom line. And let's try to fix that, and ensuring that you folks have those tools to actually do your job. So based on the findings of the review, I'm assuming that improvements are made internally, and you were starting to get to that answer with Mr. Strahl. Or do the improvements require legislative changes or amendments?
At this point, we've made a number of improvements, as I mentioned before, related to our process, and we have seen some positive outcomes as a result of the improvements that we have made. Some of our improvements are related, like I said, to processing efficiency, where we found efficiencies in the intake of information. We also have some other processing improvements, such as the batching we mentioned, which allows us to be able to more effectively handle the complaint volumes. We also have improvements in adjudication, where we've come forward with shortened decisions, where we've reduced our time to issue an adjudication decision from 144 days to 40 days in total. So we do have some progress. We also have some usability efficiencies going forward. We are trying to be increasingly transparent on our case status updates. So we have put information online to help passengers understand where they are in our process in terms of the backlog in total, but also to understand our process and where they're at to help them navigate. We're also working at posting soon the number of complaints or the volume of complaints per 100 flights for each airline as well, so to provide further information on the performance of the air industry too. We've undertaken and we've kicked off a more detailed review of our processes that are going to be looking at not only how to improve our processes, but also the opportunities that elements like automation could provide us, particularly the early parts of our process, so that we could, for example, automate some of the review of complaints to be able to find further efficiencies and allocate our resources towards the more complex part of our processes. Because of the volumes have increased so substantially, we need to really move to an operational organization, one that used to resolve 1,000 complaints, now resolving 30,000 complaints. We do require a reset.
So
to do that.
if I may, I've only got a certain amount of time here, so I'm going to jump into the next question. Thank you, Ms. Hutton, or Ms. Greenshields. How recently has the CTA recommended legislative changes to enhance your performance?
Chair, the agency every year in its annual report is required to provide an assessment of the Act. So in our last annual report, you'll see recommended changes to the Act.
I'm going to switch over to Mr. Hutton now. Mr. Hutton, a question to you with respect to the CTA mandate. Who ensures that the CTA mandate is adhered to over and above establishing or updating legislation versus forcing individuals to have to pursue complaints through the courts?
So in terms of the mandate, Mr. Chair, that's a reporting accountability both to the minister but also to Parliament.
And if there's changes that have to be made, what prompts those changes?
A number of factors can prompt the changes. It includes discussions with stakeholders, as was referenced earlier, summit that the minister hosted last week with industry partners, including consumer groups, is one way of looking at how improvements can be made. That also includes tools that the agency may or may not have to improve the efficiency of the overall national transportation system. In addition, as mentioned, we collaborate closely with the agency on operational needs that they may have, and it includes where there may be opportunities for some improvement in terms of the legislation and authorities that the agency could use to enhance their effectiveness. As well, as in the past, there's been a statutory review of the Transportation Act, and out of that review often comes recommendations as well pertaining to the role and mandate of the agency.
Thank you very much, Mr. Badaway, and thank you, Mr. Hutton. Prochainement, nous avons M. Barcel-Duval. Mr. Barcel-Duval, vous avez 2 minutes.
Mr. Barcel-Duval, you have 2.5 minutes. Thank you, Mr. Chair. Earlier, I think my colleague, Mr. Beckrek, had touched on this topic around complaints that are dropped. They're dropped throughout the process. Do you have an idea of the number of complaints or the proportion of complaints that are abandoned by consumers?
Chair, what we track are the number of complaints that we have at each stage of the process. So, as I mentioned, 97% of the complaints that come to us are dealt with in facilitation. That results in a resolution or a termination of the case in agreement with the airline and the passenger.
Donc, ce que vous nous dites, c'est que 97
So what you're saying is that 97% of the complaints are dealt with through facilitation. So there's not more than 3% of them that are dropped. Because out of that 3%, that also includes the complaints that go to adjudication, if I've understood correctly. Is that right?
Chair, I believe the answer to that question is yes. So 97% dealt with at facilitation, and then the rest go further in the process. That 97%, I should emphasize, doesn't always mean that all the parties are happy with what happens in the facilitation stage, but there is an understanding that the solution reached in facilitation is the correct one.
Concernant l'information, parce que on a
Now, we have some consumer associations that told us that very often people aboard a plane don't even know they have rights, even if the airlines have the duty to inform them of their rights and to let them know what remedies are available to them. What is done so that passengers know what their rights are? Do you keep an eye on the airlines to make sure they're informing passengers of their rights? How do you do that?
Monsieur le Président, en effet,
Mr. Chair, an important part of our enforcement of the APPRs is to make sure that airlines have on their website, at the counter, and in the announcements that are made, that they provide the necessary information. And that's specified in the regulations. They have to offer that information so that passengers are informed of their rights. Thank you very much, Mr. Uman.
Next, we have Mr. Bachrach. Mr. Bachrach, the floor is yours. You have 2.5 minutes.
Thank you, Mr. Chair. Mr. Uman, the DOT in the United States has fined major airlines $7 million. How much in fines has the CTA levied against Canada's airlines?
So, Chair, we post on our website all the administrative monetary penalties that have been issued against by the agency. We do that by year and by different area. So that.
Do you know the total, though, Mr. Uman?
Chair, we do know the total. So, so specifically related to the APPR, the agency has issued $171,000 in AMPs, many of which were issued since April 1st of this year.
$7 million versus $171,000. Separate question, how did the CTA communicate to airlines it intends to use Section 67.4?
Chair, there's a formal procedure of pleadings in complaint cases. So the way the process works is when there's a complaint before the agency, there are several steps at which the agency issues information or decisions, intermediate decisions, and at an early stage, what the agency will say to the two parties in the dispute, it is the intention of it is.
I guess what I'm asking, is that information public? Is it posted on your website somewhere? Can we find the communication with the airlines?
The communication, Chair, the communication with the airlines is with the airlines and the passenger who are party to that particular case.
What information can passengers obtain in order to decide whether to pursue a complaint? So I'm on a flight that's been canceled. I send an email to Air Canada or WestJet or whatever airline I'm on. They send me back an email saying, sorry, we'll give you a voucher, but otherwise you're out of luck. What information am I entitled to in order to decide whether I have a case to complain to the CTA?
Chair, actually, that's something that the agency is actually proud of. We have made efforts to put a lot of information on our website, in particular for the question that was just raised. When complainants go to our website and are trying to determine what their rights are and what their next steps in potentially doing a complaint are, there's a bunch of drop-down menus.
I guess what I'm getting at, Mr. Chair, through you, is what information about that flight, about those circumstances?
Thank you, Mr. Bachrach. Unfortunately, there's no time left for the first panel. I want to thank all of our witnesses on behalf of all of the members for their testimony today. We will now suspend for 2 minutes as we transfer over to the witnesses for our second panel. The meeting is now suspended. I call this meeting back to order. Appearing before us for the second round, we have Mr. Jeff Morrison, President and Chief Executive Officer of the National Airlines Council of Canada, as well as Mr. Andrew Gibbons from WestJet Airlines. We will begin with Mr. Gibbons for your opening remarks. You have 5 minutes.
Merci, Monsieur le Président. Thank you, Mr. Chair. It's my pleasure to be here with you this afternoon to outline WestJet's views on the air passenger protection regulations, provide our policy recommendations for the work before you, and take your questions and feedback. We welcome this discussion. Our relationship with our valued guests is embedded in the fabric of our company and our world-famous employees. Before I comment on government regulations, I want to express on behalf of our organization our sincere appreciation and gratitude for our employees. I'm sure this is shared by members of Parliament. They are the people who brought Canadians home in the early stages of the pandemic, rescued Canadians from hurricanes and storms, both here in Canada and afar. They have been on the front lines of COVID implementing government measures with absolute professionalism. They have persevered through various policies that saw many of them lose their jobs forever or for a short period of time. Simply put, they are the best. No one in Canada hates to see a guest travel delayed or cancelled more than an airline employee. Despite having the best employees possible, modern aircraft, and an unwavering commitment, things can and do go wrong. We accept we are accountable to Parliament and the public, and that's why we're here today. Where we have failed our guests, we accept responsibility, apologize in earnest, and turn over every stone to improve ourselves. To our guests whose travel has been negatively impacted by any group that provides a service to the traveler, we also apologize. Most importantly, we want you to know we are working to make sure the travel system is improved so that delays and cancellations are minimized and that every single service provided as part of your journey is accountable, just like we are. For the path forward, the WestJet Group has 4 main recommendations for the committee to consider. 1, we believe the government should prioritize a shared accountability framework for the air traveler. This regime should expand those accountable under regulations to not just airlines. 2, the Government of Canada should end what is called the small carrier provision, which treats travelers unequally on the same routing and within the aviation system. A traveler is a traveler is a traveler. We believe this confusing and inconsistent policy should evolve. 3, we believe that parliamentarians should resist the urge for major reforms to APPR or increase pressures on airlines during a fragile recovery. As we just heard from the Transport Canada and the CTA, it was December 2019 that the regulations came into place, and we have yet to see a period of stability to properly assess the APPRs outside of COVID chaos and operational chaos. We recommend that our policy energy be focused on improving the system. Number 4, safety is sacred and must remain so in regulations and in the public domain. This was an original principle of APPR and should firmly remain so. On shared accountability, aviation is a critical and complex system. There are many factors that play into any disruption or incident. As Minister Alghabra rightly noted several times during the spring and summer, there is no one group to blame for service issues, and we agree. Unfortunately, under APPR, there is only one group that has regulations and compensation, the airline. It is important that in order for passengers' rights to be protected, that every single stakeholder in the sector has established service levels that they are accountable for. We therefore call on the committee and the government to establish service level standards, communications protocols, and a reimbursement regime for all groups who provide a service that can result in a delay or cancellation. This will likely require additional powers to the regulator to make determinations that will impact CBSA, NAV Canada, airport authorities, CBSA, and other partners in the supply chain. This is both the greatest lesson of the problems of the spring and summer, but also the greatest path to a shared objective, which is to minimize complaints. On the small carrier provision, for a passenger rights program to be beneficial, it needs to treat all partners and passengers equally. Similarly to this end, there should no longer be a distinction between large and small carriers. To a passenger, a flight on WestJet is no different than other carriers. A flight from Calgary to Toronto is the same. It's the same aircraft, serving the same destination, but their rights are different. They are different with respect to both compensation tables, but also on rebooking obligations. This confusing regulation should be eliminated, and we recommend the committee enclose that in their recommendations. Thirdly, there's been a lot of discussion on safety at these hearings and in the media. Here I would request that the committee take testimony from the member of Notre Dame de Grâce Westmount, who authored the APPR as Transport Minister. It was very clear at the time that for him and Transport Canada, APPR was not intended to capture safety delays and cancellations. It was clearly intended to address commercial decisions made by airlines. Our view is that safety should always remain sacred and ring-fenced from additional penalties. Finally, Mr. Chair, with respect to new policies, we need to remember that Canada is a very different market from the USA and Europe. There are many comparisons of passenger rights regimes that exist. However, we have a vastly different climate geographic, and population base. For example, the highest snowfall days in Europe is 20 per year, and that's in very few locations. Canada has between 55 and 100 a year, which makes for an incredibly more challenging operational environment. Also, our major populations are far and more spread out. We believe that in the context of a fragile recovery, these recommendations are both reasonable and responsible. They represent the best path forward towards our shared objective, which is less complaints and a more resilient aviation system. I'm happy to take questions and look forward to the discussion. Thank you.
Thank you very much, Mr. Gibbons, for your opening remarks. Next, we have Mr. Morrison. Mr. Morrison, the floor is yours. You have 5 minutes.
Well, thank you, Mr. Chair. My name is Jeff Morrison. I'm the president of the National Airlines Council of Canada. Unfortunately, my colleague Suzanne Acton-Gervais was unable to join today. NAC, for those who don't know, represents Canada's largest passenger airlines, including Air Canada, Air Transat, Jazz Aviation, and WestJet. Second only to safety, the most important component of world-class travel is a great experience for passengers. That said, sometimes circumstances can cause trip disruptions. There's no question that there are several factors that can disrupt the passenger journey. For example, inclement weather, mechanical issues with the aircraft, or unseen operating crew shortages. Disruptive factors were amplified this past year as air travel emerged from the pandemic, and that has raised questions about APPR. So in order to inform this committee's review of the regulations, let me share some observations. First, airlines are adhering to APPR regulations. In cases of disruptions, flights are being refunded or rebooked, and hotel, food vouchers, and compensation are being provided where required. In fact, the CTA recently conducted a verification of airline processes in controlling major disruptions, where it found that no systemic issues of concern were identified, which was the same conclusion as a similar verification review back in 2020. And by the way, this is despite the fact that the APPR was not designed with a pandemic in mind. The pandemic was disastrous for air travel globally. Every organization, every agency in the industry in Canada and around the world faced challenges that continued into this summer. Still, passengers, of course, have the right to appeal to the CTA when they feel a response to a disruption was unfair. Although it is true that there is currently a backlog of complaints due to the unique circumstances this summer, and you just heard about it in the first panel, new regulations and greater promotion as well. The fact is, as you heard from the CTA, the fact is that over 97% of complaints to the CTA are resolved amicably between the passenger and airline. Another key point is that delays or disruptions in air travel often arise because of that interconnected nature of the operations of all players in the aviation ecosystem. Airlines don't operate in isolation. They are the customers of airports and air navigation service providers, and they rely on numerous organizations and agencies for baggage handling, security screening, border agents, air traffic control, and so forth. Yet, as my colleague Mr. Gibbons just said, under APPR, there is no accountability nor service standards in place for any of those other organizations. For example, if an airline has to delay and leave a passenger sitting in a terminal for, say, 3 hours, they owe you $400. But if Canada Customs or a NAVCAN problem forces you to sit on an aircraft for 4 hours, they owe you nothing. Donc, la meilleure façon d'améliorer le régime RPPO.
The best way to improve the APPR regime is to minimize the need for its use in the first place. And so our key recommendation is for the introduction of accountable service standards for all organizations and agencies involved in the air travel ecosystem. Some commentators have charged that safety is being used as an excuse to justify disruptions and delays. They suggest airlines cancel flights citing safety to avoid penalties. This claim is false and irresponsible.
Disruptions are costly and they impact everyone. They throw off, of course, passenger travel plans, but they reverberate through an entire day's schedule, through employee work schedules and airport operations. Canceling or delaying a flight, except for safety, is always a carrier's last option. But safety is non-negotiable. And in fact, as the CTA recently commented, quote, the agency agrees that a carrier should not be penalized for it or its crew making a safety call within their discretion regarding the safe operation of an aircraft, unquote. So to conclude, Mr. Chair, it is reasonable, of course, that there be accountability for delays and disruption to passenger travel. Canada's airlines accept this through their own customer service standards and APPR. But in order to be effective, APPR needs to create accountability for all players in the air travel ecosystem. We say that with an eye towards minimizing flight disruptions and ultimately to enhance air travel and the air travel experience for all passengers, which I'm sure is something that we all agree is our common objective. Merci, Monsieur le Président. Thank you, Mr. Chair, for that.
Thank you very much, Mr. Morrison. We will begin our round of questioning with Mr. Strahl. Mr. Strahl, the floor is yours. You have 6 minutes.
Thank you, Mr. Chair. We heard from the first panel, I believe it was CTA that indicated that the purpose of the APPR was to bring airlines into compliance or to change their behavior. Mr. Gibbons, could you maybe talk, has the APPR forced your airline to change its behavior, and if so, how?
Thank you for the question, Mr. Chair. The best way to put this is our obligations to our guests extend beyond what government regulations may or may not be that day. And in a market economy, that's probably the way it should be, and it's probably the way everyone wants it to be. So, it is administratively burdensome. It is operationally difficult to comply with. This is definitely true with the accordion that we've seen throughout the COVID period around restrictions and what have you. And that's why one of the 4 recommendations that we've put before you today is just to say we actually haven't had a period of stability to assess them during a regular period of time with relative stability in the sector. As an organization, we take a lot of pride in this, Mr. Strahl. We take a lot of pride in our guest service over the last 26 years. And while we are obligated to comply, while we respect the fact we have to comply, and while we take it incredibly seriously, it's not the start and finish of our relationship with our guests.
Last week, we heard from some airline passenger rights advocates who indicated that the airlines were, and Mr. Morrison referenced it to just now, using the safety. They wanted that safety, the ability to cite safety, to be completely removed from the APPR altogether. I talked about the airport I use most frequently, obviously, is Vancouver International and Ottawa International. Those are, it's a region serving 3+ million people and serving 1 million people. If you have, for instance, a pilot that is sick or there's someone's overtime because of delays, I would assume it's relatively easy to get staff. How do you deal with that? The example that was used was about a pilot calling in sick in a remote airport or a less busy airport where you have less staff. How do you deal with staffing issues to the point that you can foresee someone falling ill, or what do you believe the obligation should be to WestJet to have crews on standby or ready to fill in should an unexpected absence occur?
Sure. I can start off on that one. There was an incident. There's been some. I don't want to say misreporting, but there was an incident at the Regina Airport where we had a first officer call in sick an hour before their flight, Mr. Strahl. That might be the incident you're referring to. And it was remarked in the media and some members of the committee that we were challenging whether or not we had any obligations. That is categorically false. In that instance, what we have is a disagreement over the way this is defined and what the category should be. The way we categorized the flight was safety, and the passenger was given a hotel voucher and food vouchers and was placed on the next direct flight the next day. The question and the disagreement we have with the agency is whether or not that should be a controllable crew delay or a safety delay. And under their ruling, it's $1,000 to that guest. So that's a legitimate discussion and disagreement over what the requirement should be. But just note, it wouldn't be anyone's reasonable expectation that we have a supply of first officers in Regina waiting to be called. That's not good business practice. No one would advise us to have that. So again, it's back to these issues of balances, and it's back to what the original APPR introduced was supposed to capture and not capture.
Mr. Morrison, you had, I see that pen.
Yes, two very quick points. One, on your point about safety, to be clear here, safety, as you can imagine, is non-negotiable for airlines. That is an absolute line that will not be crossed in any way, shape, or form. And of course, safety is in part regulatory, dozens and dozens of safety regulations, and it is in part the call of pilots, where it should be, given certain circumstances. So to suggest that somehow, as I said in my remarks, that somehow safety is being used as an excuse to avoid or to has been a cause for disruption, it is not an excuse. It's a legitimate regulatory function that airlines must pursue. The second very quick point is that on the case of staff or pilots who call in sick, for example, contingency planning is something that airlines do on a daily basis. It is a very sophisticated function of what they have to do if crews or pilots call in sick or have some issue. However, as Mr. Gibbons said, it's not always possible, especially when you had a COVID period where, in fact, pilots were sick. I think we can all agree we would not want them to be going into work. But if you're in a small remote area, for example, getting a replacement crew can be difficult. So there are certain logistical challenges, some associated with geography. But again, safety is a non-negotiable function for airlines.
Thank you very much, Mr. Morrison, and thank you very much, Mr. Strahl. Next, we have Mr. Rogers. Mr. Rogers, the floor is yours. You have 6 minutes.
Thank you, Chair, and welcome again to our guest. Mr. Gibbons seems to be a frequent visitor to this committee. He's seen him a number of times over the years. It's always good to see you. Yeah. Of course, we all know the turbulent times that we could describe as extremely challenging for airlines and for people, travelers, and so on. And we often hear some of our constituents complain and talk about how they've been ignored by airlines or, given information they don't consider necessarily accurate. So from Mr. Gibbons, I guess when airlines claim that flights are delayed or canceled due to circumstances beyond their control, how is the accuracy or veracity of these claims verified?
Great question. First of all, for your guests, and we've done our very best helping your constituents and other constituents with these issues. And we had a major challenge with our contact center some time ago, and we were very transparent in public that our service at our contact center did not meet the expectations that Canadians have of our company, and we weren't afraid to say that, and the good news is we made that better. But we do know how difficult it was for guests for a certain amount of time to reach us, and it was unacceptable. With respect to who verifies, great question. The CTA actually investigated a series of flights, I believe it was 560 flights, and they found not one instance of an airline deliberately miscoding a flight. Of course, human error can occur, but I would encourage you to look at those investigation reports, and this goes to the questions that Dr. Lewis had earlier. Not one instance of a deliberate miscode of a flight. So that is how it's verified. There is a process, and I can tell you the CTA is not shy about seeking information about why we coded something this way or that way and what was the basis for it.
So, Mr. Morrison, I guess I'll put this question to you first. And what should have happened in instances where multiple and contradictory claims are made about the reasons for a delay or cancellation or lost luggage?
So thank you for the question. I've only been in the role for a month, so I hope maybe at some point I can get my frequent flyer card from this committee. But what we said earlier in terms of, the best way to address the APPR framework is to ensure that we can minimize the number of people that actually have to use it in the first place. That means improving the overall system. So for when there are disruptions, having a much more transparent, accountable system whereby each of the players and each of the organizations within that ecosystem are being transparent, public, accountable for the various actions would go a long way towards verifying claims, towards verifying causes of disruptions. Right now, that sort of shared data sharing, that sort of shared accountability, that shared measurement is not in place. If it were, we could have a much more verifiable system that ensures that, again, we're able to better understand the cause of disruptions in the first place.
Gibbons, you want to comment on that?
Yeah, I just, I was struck by what the CTA testimony, which said, 1,700 complaints in the last fiscal year before COVID and 5,800 in August. So, knock wood, the challenges we've had have been legitimately unprecedented. So it is legitimately confusing. I don't know that there's a regulatory environment or a set of regulations that could have captured how complicated these delays and cancellations are. And it's going to take some time to root through that. But on any given evening during the operational crisis of the spring and summer, your delay or cancel could have been the customs haul, it could have been our own baggage, it could have been any of these things. So there's a point to be made. It is legitimately complicated.
Thank you very much, Mr. Gibbons. And I can't pass up the opportunity to ask you this question, even though it digresses a little bit. So WestJet has been a great airline, and your employees have been great people. I've flown with them a number of times. What are your long-term plans for Eastern Canada, in particular Atlantic Canada?
Thank you for the question. In Central and Eastern Canada, it depends on where you are. My colleagues call this the East. We're in Ottawa. I think it's Central Canada. Anyway, so for Atlantic Canada specifically, we are transitioning our investments from a more traditional hub and spoke regional flying and a varied mix of flights to what we describe as more east-west and more north-south. So our investments in Atlantic Canada are changing and are evolving, and some of the regional services and some of the Q400 flights that many of the constituencies and provinces have relied on are going to change, and our investment mix will look different. That transition will take some time. We've already made some of these announcements and decisions, but it is part of a broader transition in the region coming out of COVID.
Well, hopefully it's, in the long term, it's going to be positive news for Atlantic Canada, because Atlantic Canada really relied on WestJet for providing some service to many of the hubs in the region. So
we hope so too, and we really value all our guests in Atlantic Canada and our relationship with communities, and a lot of these decisions have been difficult, and we fully recognize that. But as part of that transition that we're making, we are always open to any discussions. And I actually met with a delegation from Newfoundland and Labrador just last week to discuss about this. So our commitment is to be there and have those discussions.
Thank you very much.
Thank you very much, Mr. Rogers, and thank you, Mr. Gibbons. Prochainement, nous avons Mr. Barcelo-Duval.
Mr. Barcelo-Duval, over to you. You have 6 minutes. Thank you very much, Mr. Chair. I'll start with Mr. Gibbons. Earlier, I liked something that you highlighted. You said there was an audit by the agency. They look at flights when there are, delays or cancellations, and it was verified whether or not the categories were the right ones. And you mentioned that there didn't seem to be a single case that was revealed out of the 500 that showed that it was not the right code used. Now, since in general they seem to be the right categories, the categorization that's used when there's a change to a flight or a delay or whatnot, it's the right code. And when somebody contacts the agency, sometimes there's one single person out of 5,000 who decides to complain. So would it not be logical that there be a compensation offered to one passenger following a specific situation, for example, the wrong code or something? Would it not be logical for that to be expanded to all passengers of the same flight systematically? Thank you for the question.
The first is just the nature of our business. So if you take the 6 a.m. flight from Ottawa to Toronto, it's not like a Via Rail train where every single guest has bought that ticket from Ottawa Union to Toronto Union, has the same journey. Our flight from Ottawa to Toronto at 6 a.m., 10 people are going to the Middle East, 10 are going to the Caribbean. A guest is not a guest is not a guest on the flight. So there's a reason why the regime is based on individual travelers, because individual traveler journeys are unique, and they should have an individual right to plead their case, to provide their perspective on it, and we equally should have that obligation. Please.
Je comprends votre réponse, mais moi, je me pose la question.
I understand your response, but if I'm being told, well, the flight has been canceled for the weather, for example, or for other safety reasons, well, then I imagine that it's the same safety measure or the same weather conditions that apply to everyone on the flight. So for many cases, it could be extended to all the passengers, no?
It could be, yeah. And the APPR is designed as a minimum standard of treatment, but you're a different traveler than Mr. Bachrach is, and what a solution is, what an acceptable guest relations solution is for Mr. Bachrach might not be the same for you. And that's the beauty of commercial aviation, is there's that competitive dynamic, and that includes a competitive dynamic when it comes to compensation and amelioration.
Just put un autre exemple de ça. So for
another example,
if your flight is delayed or canceled, you were coming to Ottawa, but there's another person on that same flight who was going to, I don't know, Winnipeg, for example. Part of the APPR, part of what the good customer service of airlines they do is we'll work with the individual passenger to accommodate. So if there is an available flight immediately to Winnipeg, but there is not an immediate flight to Ottawa, the two are treated, the two have two different circumstances, and therefore that sort of blanket approach that I believe you're speaking to would not necessarily work in that case. It's also the importance of due diligence. It's why we have a uniquely Canadian approach via the CTA. That due diligence is at the cornerstone of that.
Merci. J'ai bien aimé les.
Thank you. I appreciated your answers. There's a point in your opening remarks, and we agree with it. It's when you talk about sharing the responsibility when there are cancellations of flights or other things related to government services and having standards. But from the consumer's point of view, we were told that often there's an interaction with the airline. You buy the ticket, and then that's the person you deal with when you have a problem. So, for example, for the consumer to say that it's the fault, has to figure out, is it the fault of the airline or the government or who else? Well, it becomes quite complicated for the consumer. And we were told that it should, in fact, be the airlines. It should be up to the airlines to turn to the government, when it's the government's fault, for example, to then offer the compensation. Wouldn't that be a simpler way to proceed, especially since sometimes you mentioned this, that the rules are complicated. The people from the agency told us that the rules are complicated. Those from the the consumer office told us the same thing. So wouldn't it be easier if we just simplified the rules and the compensations? Well, we'd stop saying, is it the airline's fault or somebody else's fault? For the consumer, it gets very confusing. So shouldn't there just be a systematic compensation, and then it would be up to the airline to go get that compensation from the responsible person when necessary?
Go ahead.
Respectfully, I don't think an answer for simplification is to also make airlines responsible for managing an APPR framework and relationships with all of the government agencies. We've heard from members of this committee, you're asking that your constituents get very clear information about why their flight was delayed or canceled. We agree with you. We think that they should have that precise information. And sometimes that precise information can be because the customs hall was full or because NAV Canada had a ground delay. So I think that maybe a starting point is to recommend to the minister that he come back to the committee with some framework options so that at minimum there are service standards that have to be met. And when we talk about our employees, again, respectfully, when there's a delay or cancellation in our system or Pearson Airport comes to a halt, there is a WestJet counter, there is no CBSA counter, there is no NAV Canada counter, there is no airport. Everyone ends up speaking to a WestJetter, confronting a WestJetter, asking a WestJetter for compensation for a voucher. So we're simply saying, we're simply saying we agree with the minister, there is no one person to blame, but how do we appropriately capture all that? And I would respectfully say it is not to have airlines do everything we do now and that.
Merci beaucoup, Mr. Barcelou-Duval.
Thank you very much, Mr. Barcelou-Duval.
Mr. Bachrach, the floor is yours. You have 6 minutes.
Thank you, Mr. Chair, and thank you to Mr. Gibbons and Mr. Morrison. I just wanted to make sure I understood correctly that if Mr. Barcelou-Duval and I are on the same flight and he gets compensation, you're going to provide me with compensation as well, right? This is
What you will receive is the same service from airlines to ensure that you are ultimately getting to where you want to go, which, of course, is the purpose of the flight.
Now, airlines have the ability to award passengers compensation under the APPR without the passenger complaining to the CTA. Has this ever occurred, to your knowledge, since the APPR has come into effect?
Have we provided compensatory, just to make sure I understand your question?
Well,
the question is, have we compensated guests,
so
regardless of whether they've spoken to
the
regulator?
APPR lays out compensation for delays. More than 3 hours, it's a certain amount of money. More than 9 hours, it's a certain amount of money, $1,000. Has WestJet compensated passengers in accordance with the APPR without passengers having to go to the CTA and file a complaint?
Yes, of course, and it's our preference that we do that on our own accord and not have a guest need to go to the CTA. So the answer is yes, absolutely we have.
And Mr. Morrison, is that the case for other airlines that you represent?
So airlines are not always privy to divulge their practices, so we can't confirm that. What I can, just going on a slightly different tangent, what I can confirm for you, because this was discussed at the prior session, is when you talk about the CTA complaint process, as we said, 97% are adjudicated through, or excuse me, are addressed through facilitation. Just by way of numbers, 3,800 in 2021-22, 3,825 were processed by facilitation, 148 by mediation, 124 by adjudication. So, and 0 by arbitration. So it is a very, very small percentage in which that more formal adjudication process is required. It is, for the most part, as was stated earlier, a fairly congenial situation.
I'm going to move on to a slightly different topic. In the EU, when a pilot is sick, the passenger gets compensation. It's not an extraordinary circumstance under the EU regulations. Why should it be different in Canada, or should it be?
Do you want to, sir?
You go ahead.
Okay. No, thank you for the question, and it's a good question and one we've thought about. When the minister of the day first introduced APPR, he made it very clear that the framework was meant to be very fair and balanced. There is a certain balance required. In Canada, unlike the EU, of course, we have a very unique Canadian institution, the CTA, that adjudicates complaints. There's also, as Mr. Gibbons mentioned in his opening statement, some very, very different geographical population differences between Canada and the EU. Winnipeg gets a lot more snow days than London or Paris, as an example. Being able to fly a alternative pilot from London to Paris is much simpler than it is from, say, Happy Valley Goose Bay than to Winnipeg to Vancouver. So there are some very different circumstances between the EU and Canadian regulations and environments where the two don't necessarily are not necessarily aligned.
It seems like the APPR, at the heart of this issue, is the APPR distinction between matters that are within an airline's control and matters that lie outside an airline's control. And yet, if you read the Canadian Transportation Act, it actually provides 3 categories. Within an airline's control but required for safety, and outside an airline's control. It's been suggested at previous meetings that the legislation be simplified to have 2 categories: inside an airline's control and outside an airline's control. Would you support that approach if the CTA and Transport Canada provided specific guidance on what issues fall into those 2 categories?
I think the guidance is the important part there, and some certainty around what the regulators' rulings would or would not be. As I cited earlier, there was a ruling that we disagreed with and we believe is contrary to the original intent of APPR. So the short answer is it depends. If it benefits the Canadian traveler and gives them more certainty and doesn't unfairly penalize airlines, then that's something we'd be open to. Those are the principles that guide us. Will it benefit the Canadian traveler? Will it inform them properly about why they were delayed and canceled? And will it make the system as strong as possible so that we don't have to be at Transport Committee talking about delays and backlogs? So if it meets those objectives, it's something we would strongly consider.
I guess the issue here really is that we want to ensure, obviously, that that safety is never compromised, that every flight that takes off is safe to fly, but also that passengers are treated fairly. And I think the challenge here, if I understand this whole issue correctly, is that there is this vague gray area in the middle, things that airlines suggest are for safety reasons, and it would seem to me as a member of the flying public that most things related to airplanes also relate to safety. It's amazing that we're able to fly the way that we do. How do we strike the right balance? Because it seems like currently there are a lot of instances where things like crew shortages and other issues that seem to be within an airline's control. Maintenance would be the other one. I'm trying to think of a maintenance-related issue that would lie, or a mechanical-related issue that would lie outside an airline's control. Perhaps you could offer some examples of mechanical issues outside of your control.
15-second response, please.
I think the answer to your question is in the recommendations we proposed. So for me, Mr. Bachrach, you're asking questions about the system that's in place to govern how airlines code, don't code, where we pay, where we don't pay. But nothing exists for any other consumer-facing activity in Canada the way airlines have, and no other. We respect them all, they're all wonderful partners, but no one else in the commercial aviation system that provides a service has one obligation even similar. So we can work on imperfections around the existing APPR and coding and whether airlines should do this or that.
Thank you very much,
But at the
Mr.
end of the day,
Gibbons.
we are alone in that obligation.
Thank you, Mr. Gibbons, and thank you, Mr. Bachrach. Next, we have Mr. Lewis. Mr. Lewis, the floor is yours. You have 5 minutes.
Thank you, Mr. Chair. Thank you to both the witnesses this afternoon. Interesting testimony. So first and foremost, to you, Mr. Gibbons, I just want to say thank you for celebrating your labor force, for your team. That to me is pretty awesome that you recognize that they are first and foremost. And I'm quite sure it's not just WestJet; it could be any one of our airlines. But congratulations on that front. So to that extent, sir, what specifically is WestJet doing to support them? And to take it a step further, what more could the government be doing to help support WestJet to get more labor to the force?
Thank you very much for the question. Thank you for complimenting the WestJetters. They are great. In terms of what the government can do, I think that was part of the testimony last time I was here, which mainly focused around a stable operating environment, and that exists in a couple of different ways. Definitely there's a COVID border travel guidance discussion to have, and credit to the minister last week. He did ask for feedback on this in this regard in terms of what lessons we can learn from COVID. So we do need to thank him for making that an issue of the summit. He could have chose not to do that. He didn't, and good feedback was received, I hope. So that is, we need a stable operating environment so that people want to work in our sector. They want to come to work for our company. They want to serve Canadians. They're not worried about up and down regulations or other issues. So I think that's going to go a long way to labor stability.
Thank you, Mr. Gibbons. I appreciate that. That's good feedback. So I'm gonna switch gears here. So last Thursday, I went to the Ottawa airport. I will not name the airline. And once again, my flight. Well, long story short is I took a taxi, and I sat there for 2.5 hours to find out my flight was delayed. And so, anyways, the reasoning is it says reason. Flight schedule realignment because of earlier weather conditions, and then it has an asterisk. Category uncontrollable event. Through you, Mr. Chair, to Mr. Morrison, you had spoke about safety before. Would this be considered a safety event?
So thank you, Mr. Chair. And by the way, before answering that, I just also want to acknowledge the workforce of all of the airlines in the country. They have done exceptional work in the most incredibly difficult circumstances, so I just want to thank you for acknowledging that. I can't speak to the particulars of any specific incident. What I can say is that weather delays, of course, have a safety element related to them, but that ultimately those decisions are up to the pilots and to the individual airlines. As I said in my opening statement, cancellation of a flight is the last resort. It is only used if the pilots and decision makers are feeling that there is a safety concern, but in no way, shape, or form do they do it lightly.
Thank you, Mr. Morrison. So to take that one step further, I'm just down to my last minute, 50 seconds here. So about 3 weeks ago, I was, the exact same thing happened. Okay, so I went to the Ottawa airport. I was sent back home. Thank goodness I've got an apartment here in Ottawa, so I've got a place to stay. So I was rebooked on the next morning flight at 7 o'clock. That flight got canceled. Then I was rebooked at 3 o'clock in the afternoon. That flight got canceled. So, sorry, that one got me to Toronto. My Toronto flight was canceled. I jumped on an Uber and I drove to Windsor. My question, because I believe it was you, sir, that said there's a responsibility of the airlines that they have to rebook you within 48 hours. That second rebooking, does my 48 hours start again? And my third rebooking, does it start again? And my fourth, does it start again? Or is it from the very first time that my flight was delayed?
Yeah, I would have to verify that, Mr. Lewis, with the regulators to be clear on that. What I can say is on the 48 hours, that of course that is the maximum time provided for in the regulations. The vast majority of the cases are nowhere near that. Airline crews, we talked about the fantastic work that airline crews have been doing over the past 2 years. They will endeavor to put you on the quickest or the most available next flight available. So we do apologize for the incidents that you suffered, but in most cases, that next available flight will be much shorter than the 48-hour window provided for.
Thank you, Mr. Morrison, and I've only got about 20 seconds left, so I want to thank you both again, gentlemen. Thanks for answering my questions as truthful as you could. Thanks again to your labor force, and if you would, Mr. Morrison, would you please follow up with this committee just with an answer, a written response to that last question I asked. Thank you, Chair.
Thank you very much, Mr. Lewis. Next, we have Ms. Katrakis. Ms. Katrakis, the floor is yours. You have 5 minutes.
Thank you, Mr. Chair. Witnesses for being here today. It's very nice to see you again, Mr. Morrison. We crossed paths at last week's Air Sector Recovery Summit, which was one of the subjects that we discussed was precisely APPR. So it's really nice to see you here again. I wanted to go further into, the shared accountability, Mr. Gibbons, and I just wanted to say and point out, and for the record, that the CBSA and CATSA employees can and do receive complaints. So when there are airport problems. So they may not be directly in the APPR the way that airlines are, but they do receive complaints in that regard. Also in the same vein, CATSA and CBSA are if they're going to also be part of, maybe compensating passengers, isn't that like the federal government using money to pay passengers as well? What do I mean by that? And I'm going to read my question because I want to make sure I get this right. Presumably, if CATSA and CBSA were subject to the APPR, would they be required to pay travelers compensation if they play a part in poor service at airports? And these are federally funded entities, so the federal government would essentially be fining itself. Does that make sense?
I think what we're trying to achieve is more transparency for everyone who delivers a service that can result in a delay and cancellation. So while we were very committed to not playing the blame game during our crisis with you and the minister, we can observe that there was some Friday nights in Toronto Pearson Airport where 700 guests missed their connections for one reason, and we can identify what that reason was, and that was a customs hall that was overwhelmed for whatever reason. It had nothing to do with the people who run our airplanes, and these flights that were arriving at the gate often were held for 2 hours, something we're fined for. So we're asking very reasonably, whether it's service level standards or compensation, what is the best mechanism for the Government of Canada to ensure Canadians understand and appreciate what the roles and responsibilities of those different actors are. With respect to your question around compensation, The question we have for the government is, should we be the insurance provider for all service providers in the entire sector simply because we have a contract with the guests? Is that right and reasonable, and what are the negative impacts of that? So our recommendation to the committee is to focus on fixing the actual system so that there are no complaints and we don't have to retrieve any money from anyone else who makes an error, and that we have a well-functioning system.
Would you like to add to that, Mr. Morrison?
Yeah, and by the way, very nice to have met you as well. Our recommendations regarding the shared accountability model are not meant to be punitive. They're not. I think we would still need to have conversation, consultation, engagement with all the players. First of all, to define what that framework would look like. Secondly, to define how those metrics and how those sort of accountability standards could be enforced. We're not necessarily suggesting that there be a financial penalty in that regard, but that's part of the conversation that we would need to have. I would frankly argue that if the federal government would be looking to improve the travel system, there are many ways in which it can do that, including reinvesting in Canada's airports. But really, the purpose for those recommendations is, frankly, to improve the overall travel experience so that passengers don't have to use APPR in the first place. That, by far, is the best way in which we could improve the regime.
The other question I have to either of you, and maybe Mr. Gibbons, you can start. What are you doing to make sure that the passengers, the traveler next summer is going to have a much better experience than it did last year? What are you and your colleagues doing at WestJet to make sure that you are better prepared or to offer a better client experience this time around?
Sure. Well, first and foremost, we're working with the minister and all sector partners. And he, to his credit, and I said this at committee last time, he brought all of these groups together to alleviate a lot of problems for the Canadian traveler, and we worked very collaboratively with him. So our request is that that level of engagement continue on a regular basis, that all service providers, no matter what your role in the system is, are together planning out very peak operation periods, including this Christmas. So number one is to continue that work. Number two is to stabilize our operation and our own business. Right, and we have an obligation to do that, and we're accountable when we fail to do that, and I think that's reflected in the recommendations, here today. So we play a role for sure, and we've been held accountable for that role as we should be.
Thank you very much, Ms. Koutrakis, and thank you, Mr. Gibbons. Prochainement, nous avons Mr. Barcelou-Duval. Mr. Barcelou-Duval, la parole.
Mr. Barcelou-Duval, 2.5 minutes. For Mr. Morrison, but Mr. Gibbons could respond as well. A little earlier today, there was this question of whether or not we should take inspiration from, and this came from our previous meeting with other witnesses, should we take inspiration from American and European regulations when it comes to compensation for passengers? Because there are for a lot of aspects, they're more stringent. I understand your response for the time being is no, but I'm still wondering about this response of no, because when we talk about standards at all levels, whether that's aviation, accountability or accounting or regulations in general, there's always an attempt to say, well, what would simplify things? That it's to have standards that are similar from one place to another. And the main players, the main partners for Canada are Europe and the U.S. So why don't we go after standards, service standards, and other standards that have to do with compensation for passengers, ones that are similar here compared to Europe and the U.S., because consumers coming from those places probably expect to have a similar support that they get back home, no?
I think
I'll answer in English.
International counterparts about how we can best simplify, how we can better improve the travel experience in Canada. They always come back to putting in place a stronger aviation system overall. They refer to the fees paid in Canada, which are significantly higher than that paid in Europe or the United States. So there are many ways in which they seek to improve the overall system. In terms of the regulations regarding APPR, I think there's an understanding that there are similarities between the two. That central focus of the need to rebook a passenger in the event of disruptions is common across. With respect to Canada, again, there are some, as I stated earlier, there are some geographical, some population, significant differences that would suggest that an equivalency set of regulations between Canada and the EU, for example, would not be that same sort of fair and balanced approach that the previous minister had addressed. So there's a number of reasons why perhaps it wouldn't work, but there are some things we can do better that the Europeans and other international carriers have asked for in the Canadian system.
Merci beaucoup, Mr. Basson-Louval. Thank you, Mr. Morrison. And finally, for today, we have Mr. Bachrach. Mr. Bachrach, floor is yours. You have 2.5 minutes.
Thank you, Mr. Chair. I want you to, for a second, bear with me while I walk through a scenario. From a passenger's perspective, a delay or a cancellation related to something that is within a carrier's control feels exactly the same as a delay or a cancellation that is within a carrier's control but related to safety. Now, the APPR is the Air Passenger Protection Regulations. Why should air passengers not be compensated in exactly the same way for those two different scenarios?
I think that's a great question for the author of the APPR. I mentioned in my remarks, there was a lot of discussion and debate around this precise issue when he wrote the regulations and when he testified at committee and introduced them to Canada's Parliament. I think it's probably worthwhile to revisit those arguments at that time. And I want to note that if it's not within our control, I don't want to leave the false impression that the guest is not cared for by our organization. They are. The question is the extent to which, right? And that's the example I gave earlier about the gentleman in Regina. It's not an all or nothing issue. The guests will always be looked after by our company consistent with the APPR. The question is whether additional entitlements and additional penalties are warranted, and that's where we have differences.
Sure. My last question, and I know we're almost out of time. If we look at this issue broadly, I think it's interesting to think about what the indicators of success actually look like. And one of the main indicators, in my view, would be that the traveling public is satisfied with the service that they're receiving and the way that they're compensated when they're disadvantaged or inconvenienced. Now, we're in a situation right now where everyone seems really ticked off by the situation. There are thousands of Canadians who had their lives upended. There were people sleeping on the floors of our airports. There are people, I've been on flights that have been canceled without any reason whatsoever, with absolutely no care for the experience of the passenger. So, regardless of what the specific prescription for remedying the situation is, I think we all agree that things as they stand right now are not tenable. To both of the gentlemen before us, do you agree that the minister should open up the APPR and fix the regulations?
Very quickly, Mr. Bachrach, first of all, the question about the satisfaction and that should be the main indicator, without question. Being able to get from point A to point B safely, efficiently, should be by far the main objective, and it is for airlines. Has there been disruptions? No question. Again, I think the experience of the past 2 years, very much pandemic related, so we need to sort of put that into context. But should the minister be looking to open APPR? Again, I would argue that the most efficient improvement to the APPR is to ensure people never have to use it, or we reduce or minimize the need for its use by passengers in the first place. That's why we've called for an overall improvement to the system, so that if passengers can get from A to B efficiently, that is the metric of success that we want to promote.
We believe it should be opened up. There's some key areas that we've recommended. We believe it should be opened up to give the CTA some ability to get information from other service providers the way they do for us. So that shared accountability framework should be part of the opening up. Part of the opening up should be eliminating the small carrier provision, so that all travelers are treated equally.
I think that's a perfect way to end, Mr. Gibbons.
So yeah, we have our own recommendations for opening it up, but like Mr. Morrison says, first and foremost, it's the system. And I just go back to the CTA's testimony: 1,700 complaints in the last fiscal year before COVID started, 5,800 in August. We didn't forget how to staff airplanes and manage our business. We're one of the most successful airlines in the world. So we need a period of stability to get our solid footing financially and otherwise So our recommendation is not to make major incursions at this time, so as to allow for.
Thank
definitely it
you
is to
very much,
implement our
Mr. Gibbons.
recommendations,
I'm
but
going to
other
have to
things-
end it there, unfortunately. On behalf of all committee members, I want to thank our witnesses for their testimony today. And with that, this meeting is adjourned.